Welcome, students, to Human Services Class 280 on Ethics and Other Responsibilities for Human Services Workers. We have 5 full classes involving law and ethics. This first one is on definitions. Please notice the references used for the creation of these PowerPoints as posted in the Files menu under Law and Ethics. What are ethics? Why are they important in treatment, counseling, and case management? Shouldn't everybody do the right thing? How and why do ethics get broken? What are some of the consequences of ethics violations? These are the questions we'll be answering in tonight's lecture. What are ethics? The official definition is that ethics are moral principles adopted by an individual or group to provide rules for right conduct. Ethics involves what is right and correct. If you compare and contrast that to values, which pertain to that which is good and desirable. So ethics is the higher standard. What is ethical? Generally, what is ethical are represented in ethical codes. Each of the specific professions have their own specialized ethical codes. They are often required to maintain a professional status. Violations of ethical codes can result in sanctions and loss of privileges, meaning certification or licenses. You generally are going to need to take a course in law and ethics, usually required every 2 years. The specific codes of ethics are in the handouts and the files menu on the left-hand side. We'll get to those in a minute. What is moral? Moral choices have to do with culture and socialization, or religious standard of right conduct. What we feel is right. This is often tied to religion or upbringing. Moral behavior in one society may be immoral in another society. We generally feel guilt when we violate our own moral code. Along with moral code, there are generally moral principles. These principles reflect expert consensus on ethical priorities and values that frame the ethical decision-making in clinical care. The principles, such as respect for persons, autonomy, compassion, confidentiality, privacy, truth-telling, non-malfeasance, beneficence, justice, fidelity, and veracity. These form a necessary foundation for clinicians who treat patients with substance abuse or dependence. To be effective, professionals caring for individuals with addictions will ideally embody the virtuous dispositions of altruism and fidelity, among others, if they are to internalize and integrate the cognitive principles into their practice. What is legal? The two main laws that we are talking about in this course with regards to substance use disorders are HIPAA, Health Insurance Portability and Accountability Act, and 42 CFR, also known as Section 42 in the Code of Federal Regulations, Part 2. Both are federal laws, so we're going to get to know those pretty well. HIPAA, the Health Insurance Portability and Accountability Act, was enacted in 1996 by the U.S. Congress. HIPAA realizes that there is a critical need to balance the steps taken for the protection of an individual's health information, along with the provision of proper healthcare facilities. The privacy rule, which is HIPAA, strives hard to regulate the sharing of protected health information, PHI, without making it a deterrent for accessing healthcare facilities. Thus, the privacy rule does permit disclosures under certain circumstances. Prior to HIPAA, no generally accepted set of security standards or general requirements for protecting health information existed in the healthcare industry. At the same time, new technologies were evolving and the healthcare industry began to move away from paper files and rely more heavily on the use of electronic information systems to pay claims, answer eligibility questions, provide health information, and conduct a host of other administrative and clinically based functions. Today, healthcare providers are using clinical applications such as computerized physician order entry systems, electronic health records, known as EHR, and radiology, pharmacy, and laboratory systems. Health plans are providing access to claims and care management, as well as member self-service applications. While this means that the medical workforce can be more mobile and efficient, i.e., physicians can check on patient records and test results from wherever they are, the rise in the adoption rates of these technologies increase the potential security risks. So HIPAA was really needed. The NPI is a 10-digit number assigned to all covered entities. It is the primary healthcare provider identification for billing transactions. When you begin to work for an organization that does billing, you will be instructed to get an NPI number. This belongs to you personally, and you will use the same number wherever you go to work. Each healthcare facility also has an NPI number. 42 CFR was promulgated in 1975 and was last changed in 1987. However, there have been recent changes in 2018. 42 CFR covers substance use disorders, excluding tobacco and caffeine for now. Federally funded programs must comply to 42 CFR. Those federally funded programs include units of government to get certain tax benefits, those who are a 501c3 who get tax benefits by being a nonprofit, those programs funded by Medicare or Medi-Cal, and those programs funded through SAMHSA through the state government or direct federal grants. those programs have to hold themselves out to provide substance use disorder, we're going to call it SUD, services through their license or certificates, by their advertising, by their names, those who are a detoxification program or a narcotic treatment program, and other ways to determine that the primary business is SUD diagnosis and treatment. We must adhere to 42 CFR, and we do this to encourage people to seek treatment without the fear that by doing so their privacy would be compromised. 42 CFR is the most stringent confidentiality regulations, even above HIPAA. If you could imagine, sharing of alcohol and drug patient information could lead to negative perceptions and discrimination, criminal legal consequences, civil legal consequences, loss of child custody, loss of employment, and loss of housing. So the consequences are real to the clients who seek services. 42 CFR Part 2 has been around much longer than HIPAA. The HIPAA privacy rule offers a floor of protection. And again, 42 CFR is more protective of privacy than even HIPAA. When healthcare providers are covered by both HIPAA privacy rule and Part 2, they must follow both regulations or laws. And when they are different, providers must follow whichever one gives patients more privacy protections. There are also applicable state of California laws. There are welfare and institution codes, business and professional codes, penal codes that all cover confidentiality. There are also applicable state regulations which cover Medi-Cal, which is known as Title 22. For those that govern the driving under the influence program, that is known as Title 9 in the California Code of Regulations, or CCR. Then, of course, there are code of ethics from professional organizations such as CADE and CCAP, as well as licensing organizations like CAMPT and the NASW, National Association of Social Workers. All of these codes, regulations, and laws are to be adhered to in our field. Now, how many of you think they never overlap? Of course they do. One of the common rules, if you will, in all of these codes, laws, and regulations is a rule that's called the need to know. Who are those that need to know about your client? Well, your treatment team members. You work together as a team. You present cases, client information as a team. There are other entities who work with the program. So, for example, maybe the drug testing laboratory works with the program and they need to know client information. Also, in medical emergencies, we need to let the medical personnel know, and that is allowable. Do they have a need to know? When there is a crime against a program or program staff, then law enforcement may need to know information about a client. When we have audits, evaluation, or research being conducted, those auditors and evaluators also need to know specific client information. And sometimes there are court orders which are issued where there is a severe crime and the information is not available elsewhere. To basically communicate with anyone else needs a release of information form signed by the client. The other rule that is common is called the minimum necessary rule. It is under 45 CFR or HIPAA. This rule says that we only release the minimum amount of information needed for the other agency to fulfill their responsibility to the client. 42 CFR, the federal regulations for drug abuse programs, are very specific and very restrictive. All client or drug abusing quote-unquote information is to be held in strict confidence. Scope of practice is a legal concept that defines what the professional in the state of California may legally provide to consumers. For drug and alcohol counselors, what is outside that scope, for example, includes providing medical advice, providing medication advice, providing legal advice, or making mental health diagnosis. Those are not allowed by drug and alcohol counselors. In the Files menu on the left-hand side under Law and Ethics, you will see the actual scope of practice handouts for licensed marriage and family therapists, licensed clinical social workers, and licensed professional clinical counselors. And we'll come back to that in a minute. But the scope of practice, and there are in the Code of Ethics, that's usually what is stated first for drug and alcohol counselors, is also available in your handouts. Now, the scope of competence is an ethical term that defines what any particular counselor in the state of California may provide to consumers. The ethical obligation is to, if you're an individual provider, that you provide services only within the education boundary, your training, your license or your certification, and consultation received and supervision experience. You slowly learn to expand your scope of competence by accepting new cases and obtaining additional education, training, experience, consultation, and supervision. So the diagram looks something like this. The scope of practice is the outer blue circle. The scope of practice, remember, is a legal concept that is described as what you can practice as a profession. And so for drug and alcohol counselors, the scope of practice includes conducting counseling services in a group, conducting individual sessions. You may do education with family and family members. That's all within the scope of practice. You can also work with anybody under the scope of practice in law. So, for example, you can work with those anybody that has a substance use disorder. They could be in jail, they could be in juvenile hall, they could be in a clinic, they could be in a school, etc. So the scope of practice is the outer blue circle. The scope of competency, remember, is the inner red circle where you have received your training and maybe you had some special courses, etc. And your scope of competency then is more limited. So maybe you never have had experience working with sex offenders who have substance use disorders, and that's not really in your scope of competency, but it would be allowed under your scope of practice. So the general thinking here is just because you are able to do everything doesn't mean that you should do everything. Your scope of competency can be expanded, and you can expand that and probably naturally will with different experiences, supervision, and extra training that you have had. But only up until your scope of practice. You should never be operating out here, meaning you are outside of your scope of practice, you're way outside your scope of competency. All of a sudden you start counseling your people about medications and medical side effects. Now you are operating outside of your scope of practice and your scope of competency. Professional competence, you have an obligation to continue to remain current of new developments in our field, and you do that through continuing education and work experiences. You seek out appropriate supervision if a course of action is unclear. You obtain professional assistance for any personal problems, illness, conflicts, which are likely to impair your work, performance, or professional judgment. We also maintain high standards in the substance use disorder field of personal and professional behavior, even outside of work hours. You need to become familiar with and support and promote the goals of the agency that you will be working with. I want to talk a little bit about licenses and certification to go through this. And basically this slide is in higher from the lowest certification, which is called registration, through certification, through licensing, and so forth. You must be registered as an alcohol and drug counselor prior to employment in an SUD treatment facility. However, you can only be a registered alcohol and drug counselor for 5 years, and that is with no exceptions. So you do not want to register too soon. You can work in a program for your own experience, let's say in your internship, prior to becoming a registered alcohol and drug counselor. However, when you're employed regularly doing the counseling work and want to begin gathering your experience hours, then you will need to be registered. In order to get registered, you're going to go on to the website, pay $100. You get to take a 9-hour course on law and ethics, and then the application package is complete, and you become registered. And again, then you're adding hours, you're getting hours of experience that can be paid or unpaid. And eventually, when you get all of your hours completed and all of your education is completed, then you get to take a written test. And if you pass it, then you become a certified alcohol and drug counselor. Now, the scope of practice, as I mentioned before, of a drug and alcohol counselor, excuse me, is to conduct group counseling sessions, preferably using standardized evidence-based curriculum. You can conduct individual counseling sessions regarding substance use disorder topics and recovery-related topics. You can provide education, prevention services, case management services. So case management services include things like drug testing services, transportation, coordination of resources and service delivery, placement into facilities. You can also provide ancillary areas of support such as socialization, recovery coaching, employment, housing, healthcare. You're linking your clients up to those services. Just a word about licensed psychiatric technicians, because Cuesta has a program. That licensing program generally focuses more on mental health, but also behavioral health issues. This is a medical program. The licensed psychiatric technician can be employed in a co-occurring disorder or in a substance use disorder program. Generally, the scope of practice of a licensed psychiatric technician is regarding medication concerns, refills of medications, counseling the clients on mental health diagnosis, signs and symptom management, healthcare concerns such as HIV, Hep C, TB, and other medical concerns. The SUD, now, of course, we have medications that are associated with our treatment programs, such as Suboxone, Naltrexone, Vivitrol, Naloxone, Methadone, and Antabuse. A licensed psychiatric technician, again with additional training and experience, can provide those services within a SUD program. Then going up the ladder, so to speak, there's a bachelor's program in social work. If you may work in the Department of Social Services or Homeless Services. And again, a lot of those clients also have substance use disorders. Then we get into the master's degree programs and various possible licenses. The master's degree programs, everyone in those programs can do diagnosing and quote unquote therapy, all have different scopes of practices. In general, for example, LCSW, licensed clinical social workers, are about the coordination of services, assessment, and resources in the community. Licensed marriage and family therapists, LMFTs, can conduct marriage, couples, family, children's services focusing on relationships. Many relationships have substance use disorders. The licensed professional clinical counselor, LPCC, provides individual counseling services in a variety of service areas. Now, the PhD programs can be done eventually, and the person is called doctor. And a person can have a PhD, be called doctor, but not be a licensed clinical psychologist. So that's kind of like myself. I have the licensed marriage and family therapist, but I also have a PhD. So I've earned the right, so to speak, to be called doctor, not to be confused with a licensed clinical psychologist. Now, you're going to need to figure this track out, this career track. I'd be happy to discuss any of these possibilities with you, either now or when I see you in person. But the primary issue here is that you need to make your registration, certification, and license known to your client, and explain that scope of practice so that the client understands your role. For example, would it be ethical for a licensed psychiatric technician to be called a therapist or refer to themselves as a counselor in the program? No, no. So this clients don't really know who is who and what their roles are. We need to explain to them what my role is in the program. And when you have many different types and scopes of practices working in a single program, this is known as a multidisciplinary team or an MDT. And that way the client themselves have a one-stop shop with everybody in one place. They don't need to go here for therapy and here for counseling and here to see the doctor. You have everybody in one place. And I think multidisciplinary teams are the way to go. The more complicated the client, the more that would be true to have a multidisciplinary team. Now, law and ethics is usually a 6 hours of continuing education units every 2-year period. So every 2 years, you're going to have law and ethics. It's just the way things go. Luckily, it does change up a little bit here and there. Now, Business and Professions Code, Section 1887.12, says that a licensee shall maintain records of their continuing education units, or CEUs. So you have to maintain your records for a period of at least 2 years from the date of the license renewal for which the course was completed. So, for example, if your license or certificate expires in May of 2019, then you need to keep proof of all of the CEU's coursework, right, done for the last 2 years, because your license is expiring. So you did these units from May 2017 to May 2019, so you need to keep those records until at least May of 2021. If you do not complete your CEUs prior to the expiration date of your certificate, then your certificate will be deemed to have expired. And this is a big mess. It will affect your employment. You won't be able to counsel with an expired certificate or license. You'll be able You'll have to be assigned to other job duties. You will not be able to renew your certificate until you have completed all of your CEUs. This is my way of saying make CEUs your priority, get your uh, certificates, your proof of those CEUs. You are the person tracking them. You are the person keeping track of them and keeping the copies for at least 2 years. This is not the responsibility of your agency. This is the responsibility of you as an individual, licensed, registered, or certified person. Now, supervision and consultation. Your supervisor must be prepared to give honest feedback to the supervisee about their skills and also about their personal process. It is not enough just to focus on the student's skills only. So as a student, you have the right to know what is expected of you, how you will be evaluated. This is in your internship and when you're gathering your hours of experience. You as a student has the right to know about training objectives and assessment procedures. You have the right to regular feedback so that you have a basis for honing and improving your skills. Effective supervision deals with the student professional as a person and as a practitioner. Supervisors need to establish a collaborative working relationship with your student. So the supervisor and the student, those roles are really important. It is up to the supervisor to maintain clear boundaries concerning the different roles. The supervisor should not be your therapist. The supervisor does notice areas of improvement that might be needed in your counseling skills. They should make recommendations to the student, perhaps that they need to seek counseling from someone else. Maybe these personal issues are affecting your counseling and professional development, but the supervisor should not be acting as the student's counselor on those issues. The supervisor's task is to strive for an optimal level of challenge in order to promote your autonomy without overwhelming the student supervisee. You as the student have an obligation to give honest feedback to your supervisor about your needs, goals, and areas of strength and improvement. Honest communication between the supervisee and the supervisor will ultimately aid both parties. It is considered unprofessional conduct if you fail to keep records consistent with sound clinical judgment, the standards of the profession, and the nature of the services being rendered. Good records indicate that the counselor is providing a good standard of care. This also means timely client records. It's not enough to say, I was going to write it down, I got busy, I didn't do my paperwork. When the emergency happens and the client record is not complete, you will be called upon to answer, why wasn't it in the file? What is timely records? The government says for Medi-Cal billing that timely record keeping is by the end of the same week of the business service when it occurred. The standard is to do all of your paperwork by the end of the week, Friday, the close of business for all services that were conducted that week. Any records over 7 days cannot be billed. Do you really have to get all your paperwork done prior to your vacation? Yes. We will come back to this topic next week when we are discussing such emergency situations such as suicidal clients, child abuse reporting, wherein really the documentation standard should occur in the same day prior to you leaving work. Good records are important, and all of these check marks, this checklist is important. Good records do provide protection in a lawsuit. It is the evidence that the services occurred. It has to match up with the financial transactions associated with that client's record. Treatment records must be retained for at least 10 years from the date of the last visit or the last transaction. For minors, they must be kept at least 10 years from the time they turn 18 or at least until the client is 25 years old. So for children, those records probably will be retained for longer than 10 years. Now, the most important document in the client's record is the treatment plan. And because if there's a lawsuit or a problem or a claim against the counselor, the treatment plan is proof that the counselor was providing an adequate standard of care and acting professionally. The treatment plan, of course, is a written document, and it should be prepared within 2 or 3 sessions. It's even better to have the client sign the treatment plan, and that way the client acknowledges an understanding of the goals and the methods of treatment so that there's no miscommunication about what was happening in treatment. The format and the content of progress notes. Progress notes are very important. It shows what happens, usually on a daily basis or when the client attends the session. Never omit relevant clinical information because a client has asked you to, or because you don't feel that the laws of confidentiality and privilege are sufficient. That is not up to you. You need to record everything that is clinically relevant into the record. Anyone who reads the notes should have some idea of client issues and what the provider did during the sessions. If there is a crisis or the need to break confidentiality, the notes should be detailed and complete in documenting the counselor's actions and the rationale for those actions. The law requires that these patient records be kept confidential. And generally that means if they're paper records, they're going to be under lock and key. If it's on a computer, you need to keep your passwords protected and safe. There needs to be separate files for all the different people receiving treatment. So, for example, you have a family program, the children's files need to be separate from the parent files, and each parent, each adult who's in treatment needs their own file. So that's really important because each member of the family has different reasons that they're in treatment and different interventions that are happening. Records also must be stored, and then when they are destroyed after the 10 years, they need to be destroyed in a manner that protects confidentiality. Clients have a right to access their records. The request to see the records must be in writing. The agency or the counselor could provide a written summary if agreeable to the client. The timeline is to have the inspection, if the client requests it, within 5 business days. If they want a copy of their records, the agency has approximately 15 business days. But if the records are extensive, then it could take up to 30 business days to get all those records ready to go. Most people think law and ethics, oh great, it's black and white. Now she's going to tell us, what to do and what not to do. There's a lot of shades of gray, and making the right decision becomes a skill that you are going to have to develop. You're going to gather as much information as you can that sheds light on a situation, the ethical situation. You're going to clarify whether the conflict is ethical, legal, or moral, or a combination of any or all of these. Remember that such dilemmas are complex, so that it is useful to look at the problem from any perspective and to avoid simplistic solutions. Because ethical dilemmas do not have a right or a wrong, black or white answer, practitioners are challenged to deal with ambiguity. It is not always black and white, and there are many, many conflicts, even within that which is a regulation or a law. Do federal and state laws always align? Of course not. When there is a conflict in the two laws, you will need to do a little bit more research. In many times, it is permissible to share information, but not required that you share it. But another law says that it is not allowed to share information. In this case, you always need to adhere to the most stringent law. That law that says that sharing information is not allowed is the one that you would adhere to in this situations. Sometimes it's even more confusing than that, and you would need ethical decisions using a process. And that's what assignment number 1 is going to be about in a couple of weeks. Here's the process. I like it because it spells out ethics. So it's a 6-step process, 1, 2, 3, 4, 5, 6. And so you have an ethical dilemma. That is a situation in which a person, you, is faced with one or more ethical obligations that cannot be fulfilled equally or at the same time. The choices are generally good and valuable, such as you want to honor the confidentiality of a suicidal patient while also wishing to protect him or her from self-harm. So you got to do both, and how do you do that? So here is the simple version of the ethical decision-making process. For E, You're going to examine relevant personal social agency, client, and professional values, gather as much information as you can, describe the critical issues, and discard the irrelevant ones. Evaluate the rights, responsibilities, and welfare of all those who are affected by the situation. Part of the process of making ethical decisions involves identifying the competing moral principles or laws. You're also going to think about what your code of ethics says and laws as well. And then you're going to hypothesize about different consequences. Of course, you're always looking at what's in the best interest, do no harm, what is in the best interest of the client. But there are different decisions. Again, it's not black and white. Identify who will benefit and who will be harmed. You're going to consult with your supervisor, select a plan of action, and then document. Code of Ethics. It is important for you to become familiar with the code of ethics of your professional organization. These codes of ethics that provide broad guidelines for the members. You will need to read and become very familiar with the code of ethics for your organization, or pick one. You're going to look at the handouts under the files in the menu. It's under Law and Ethics, and then there's a folder under Code of Ethics. Pleading ignorance of the specifics of the ethical code of your profession is not an excuse for engaging in unethical behavior. Members of the helping professions need to make and observe the ethical code of their professional organization, and you need to make sound judgments that are within the parameters of acceptable practice. We're going to encourage you to think about specific ethical issues during this course and to develop a sense of professional ethics and knowledge. So looking at the state laws, looking at the code of ethics, so that your judgment will be based on more than just what feels right to you. The purpose of a code of ethics is 3 parts. And so basically it's providing education to you and the public. It provides a mechanism for professional accountability, protecting clients from unethical practices. And it serves a basis for your self-monitoring and improving your own practice. When the word unethical is used, people too often think of gross violations of established codes. In reality, most violations of ethics probably happen quite inadvertently in counseling practices. Many ethical violations are hard to detect. Therefore, ethical codes are difficult to enforce. Clients' needs are best met when the practitioners monitor your own ethics. I would encourage you to challenge your own thinking and apply guidelines to your behavior by asking yourself, is what I am doing in the best interest of my client? Clinicians can improve their understanding of ethical dilemmas by reading articles, books on ethics, obtaining continuing education credits in ethics, which are now required in several addiction disciplines, Seeking supervision from clinicians with more experience and wisdom. Consulting ethics consultants, committees, attorneys, or professional associations. The ethical violations can have severe consequences, such as fines and fees. You could be arrested and convicted on criminal charges and jail time. You could have sanctions on your license or your certificate. You could even lose your license and your certificate, and thus your livelihood and your employment. You would not be able to do your work anymore. You could also face a civil lawsuit. So being aware of law and ethics is pretty important, and I want to keep you out of trouble. And so the next step, we're going to have a discussion forum, oops, I should say forum, for week 1 on ethics worth 10 points, and then a quiz for week 1 worth 15 points. So good luck with those.